Good evening, everyone. Welcome to the special immigration show brought to you by Sakshi TV. My name is Ranjit. We are here today with the prominent attorney, Ms. Sheela Murthy, to discuss the latest updates, followed by H1B filing issues or concerns and the common RFEs. You can call the numbers displayed on the screen and ask any question related to immigration, and our attorney will be glad to answer. Before starting the show, I would like to repeat the disclaimer. Please note this show does not provide any legal advice and it is general in nature. This show is only for informational purposes. Sakshi TV news and agents are not responsible in any way for your actions. Use this information at your own risk. You all know about Ms. Murthy. She's the founder and president of and also CEO of Murthy Law Firm and a Harvard Law School graduate. Also, she's the one behind the famous Murthy.com website. Before getting into the show, could you please briefly introduce yourself, Ms. Murthy, and then we can take it from there?
Sounds good. Hi, Ranjit. Hello, everybody. Good afternoon to you. Thank you so much for being here and for the privilege of being able to explain immigration updates to millions of people who are going through the process. Of course, as Ranjit said, Murthy.com is world famous and well known because of the wealth of valuable, free, cutting edge information that we are honored and privileged to educate, enlighten, and empower the immigrant community. We have the weekly Murthy Bulletin. We have the weekly Murthy Chat. We have the weekly free answers on the Murthy Forum that we answer. We have our monthly teleconferences for employers and for employees on hot button issues. We have a lot of podcasts that we play routinely. And we educate other immigration lawyers because we have a monthly CLE conference for lawyers, immigration lawyers, again, all free and as part of our goal to educate lawyers, because lawyers will help other clients like many of you. And we want to make sure that the immigrant population is properly served. And of course, everybody wants to come to America, the great nation of immigrants. And so we thank you for being adventurous and creative and wanting to do better for yourself and your family. So today we're going to talk about a couple of the hot topics. I don't know if Ranjit wants to ask any of the hot topics first.
Yes, Ms. Murthy. Please go ahead and let us know the updates, and then we can start the regular concept.
Okay, so a couple hot topics, of course, since we had our discussion last Tuesday on March 29th, March 30th, on last Wednesday, the USCIS released all of the people who have been accepted under the lottery. They had promised that they would release it by March 31st, but they did it one day earlier by March 30th. And we were somewhat surprised and a little disappointed because only approximately 30% of the people who submitted the pre-registration information have been selected so far. We were hoping it would be a much bigger percentage being accepted because we thought the economy and because of COVID, we are getting out of it. Maybe not as many people would have applied. So if only 30% are accepted, that means a very many people, much more than the 65,000 plus 20,000. Let's say we were allowed a total of 85,000 cases to be acceptable total overall. Then if it's only 1 in 3, that means they got probably more than 250,000 applications or 250,000, or in India, as they say, 2.5 lakh applications filed with USCIS under the pre-registration system. Remember, if you were accepted, that means you are now, your lawyer or you or your employer will have to start gathering all the information to prepare and file the petition. And you have 3 months, April, May, and June. And before June 30th, if it's not filed, then your chance is over. You have 90 days to file it. Then the USCIS may do a second lottery to see if there are any unused cases, right? And then the other hot topic that we saw just this afternoon, USCIS issued a clarification that they will not allow people to file a second 485 filing. And if you filed a second package because you thought the first one was not accepted in time, or you didn't get a receipt notice, or you're afraid that the 90-day check may expire, then USCIS has made it clear not to file it. And if you file it, you will not get a refund of your filing fees, your checks, or your package back, and if they're original documents. So please do not file a second 485. We have said this over the last 20 years repeatedly because USCIS does not want a second 485 filing, even if you have 2 completely different bases for filing the 485. So those were the 2 hot topics, and I'm sure that we have a lot of people eager and ready to ask us questions, Ranjit.
Yeah, yes, Ms. Murthy. Before we take the calls, let's start, about the topics. So, H1B filing is started, I believe, officially. And, a lot of people have a lot of issues and concerns. Could you please brief what are the things that everyone should keep in mind, either the employees or employers, to make sure, they file it on time and they file it properly, they file with proper filing fees, and nothing is missed.
Yeah, the very common problems. Sometimes a lot of companies, employers, and individuals, they don't have lawyers. They try to do it in-house, and there's nothing wrong with that. You certainly are eligible and allowed to, but you have to keep up to date with the latest changes. As you know, the forms are being changed on many all the time. USCIS is updating the forms, and they have made it very clear that if the form has expired and you send it in, and they take 3 months or 30 days or 60 days to return it, then you're finished, because now you had only a 90-day window to file. You lost your chance, and you would lose 1 year or 1.5 years time of being able to work on H1B status and make a living. So sometimes we all are penny wise, pound foolish in life, but you want to not be penny wise and pound foolish. Make sure you check the forms, check the filing fees, check the amounts, check whom it is made payable to. So many times we have heard of people saying they put the Indian date, day, month, and year instead of the other way around. And USCIS has a 6-month absolute window. Most banks have 90 days or 6 months for their checks to expire. So please make sure you date it correctly, you sign the check, the spelt out amount on the check has to match the dollar amount that you wrote. Sometimes there's a mismatch, and according to accounting laws, and many of you who have BCom graduates will know, or Bachelor of Business Administration, that the government looks at what's written, not what's written. So if you have written 495, but you write 475 because you're distracted or in a hurry, the government will return the package, and it may take them 2 or 3 months, and your filing is not considered proper. Of course, besides just the logistics and the dotting the I's, crossing the T's with checks and signing and documents and forms, you also, of course, have to make sure that you can prove and show and establish that the job duties are complex and unique and require a bachelor's degree or higher to perform, because that's the definition of specialty occupation. And you need to show a specialty occupation in order to get an H1B petition, of course. Now, some of the other issues that we have been dealing with for the past 4 years, hopefully will no longer be issues based on some of the memos being retracted, many of the lawsuits being gone. And of course, as we all know, on 31st of March, which was last Thursday, the USCIS and Department of Homeland Security allowed the presidential proclamation impacting H1B and H4 holders to expire, and that has not been renewed or extended at this point. So that now the consulates are telling people, including a lot of people, including fashion model H1Bs, certain H2Bs who are with working in landscaping business, etc., and certain people who were not able to enjoy the exemptions, the national interest exemptions, and apply while the presidential proclamation was in effect, to please submit your application now, either by Dropbox or by regular mailing process methods, in order to apply for the H1B or H4 visa, or for your family members on L1, L2, or certain J1 visa holders and H2Bs. So you are now allowed, effective as of Friday, April 1st, to start applying, because the presidential proclamation restrictions are no longer applicable, those ones that were started by Trump under the Trump administration. So those are 3 or 4 of the hottest topics and the most cutting edge issues that we are aware of in the last week that has happened with immigration. As you can see, if you are 1 week behind in immigration, you will miss out on so many important issues, because it's such a dynamic, complex, and ever-changing field in immigration.
Thanks, Ms. Murthy. Thanks for your advice. We have a caller, Raj from California. Let's take the call. Hi, Raj. Welcome to the show. Please go ahead and ask your question.
Hi, thank you for taking the call. Good afternoon, ma'am. Thank you for your time. I'm Raj from California. I have a question regarding my adjustment of status application. So this is an employment-based I-485 that was filed back in 2019 October. It's been still pending. So recently I raised a congressional inquiry, and one thing is this was filed under cross-chargeability. right? So the congressional inquiry came back saying that the visa was regressed, hence it was transferred to Texas Service Center. So I believe the officer has overlooked the cross-chargeability angle in the case. So what are my options to make them consider the case, to consider them to process the case under cross-chargeability?
When you did the congressional inquiry, did you point out that this is based on cross-chargeability and so there's a clear misunderstanding here? Or did you not bring that to the attention of the congressional aide?
Yes, so I did raise them. So basically, they sent the inquiry to the field office. The field office came back saying that, the visa was regressed. And then when the the representative called me back, I did explain to her that, this was the issue and this was filed in a cross-chargeability because I didn't know that this was not, the case was transferred and I didn't know what was the reason the case was transferred for. So the USCIS reply was very standard saying that this has been transferred to improve the processing time. But I got to know only when the lady told me that this was the response that she got from the field office. So they transferred the inquiry to Texas Service Center at this point in time. But I did make sure that I explained the issue with the case so that she understands what cross-chargeability is, and this has been filed under cross-chargeability.
Got it. So, there are different ways to do it. You can contact the CIS Ombudsman's office. There's a form 7001. You file it. It's free. You can get a copy of that form from uscis.gov. And you explain that USCIS claims that the dates have retrogressed upon contacting them, but when in fact the dates have not retrogressed because this is filed based on cross-chargeability. My spouse was born in X country, and based on cross-chargeability, we should be subject to the backlog quotas, which means that the priority dates are current. Accordingly, this case was incorrectly forwarded. Please put this on, because it's caused by USCIS error, the delay. We respectfully request that this case be transferred to an officer either for schedule an interview or for I-485 approval. So you have to push, right? We tell people, try congressional inquiry, which you've done. Try the CIS Ombudsman's office, which you are now going to do. And third, with your attorney or lawyer who helped you with the filing may be able to make contact, send a letter to try to bring this matter to the attention of the USCIS. If nothing works, we tell people, try the lawsuit angle. Unfortunately, sometimes you have to push them, and the minute they see the lawsuit and realize that they made a mistake and everything else you did before that they ignore, suddenly they wake up, Raj, and then they'll be like, oh, okay, guess what? You'll either be scheduled for an interview or you'll get the approval of the 485. That's how we have seen it happen most of the time. Some people we know say, oh, I don't want to waste money, or I don't want to file because I'm scared they'll do something to me, because we grew up with a Desi mentality thinking if we do something against the government, something bad will happen to us, when in fact we notice it is the exact opposite, at least so far in the United States, that they respect us and they're afraid of us, and they realize that we are not afraid. And in fact, then they respect you more and they will do your case, process your case faster. And even the law firms and lawyers before, when we used to be, I was similarly, because I grew up like many of you in India, I was like, maybe it's risky, maybe we should be careful. But once we started filing the lawsuits, we realized that they respect us more, and they know that if we are representing a case, they don't want to ever mess with lawyers that they know are not afraid to sue. So in the absolute worst case, keep that in your back of your mind if it's taking too long and they're messing up your life. But continue before that, try the free angles, try the ombudsman. You have done the congressional inquiry. Let them try to follow up one more time with congressional inquiry to see if they can, based on cross-chargeability, that the priority date is current and this is misunderstanding or error of USCIS to categorize it as retrogressed dates. Good luck, Raj. I hope it works out for you.
Thanks, Raj. Thanks for calling. I hope you got your answer. So yeah, Ms. Murthy, going back to our the H1B filings, what is your take on the H1B level 1, level 2 filings? A lot of people have a lot of questions, especially when it comes to fresher jobs, something like that. Is it okay to use level 1 for the LCA filing and H1B filing, or is it completely not okay?
So this is one of the areas that Biden has expressed an interest in, this whole wage level, because It is a touchy issue. It's something that many people are afraid, especially post-COVID, the impact of the economy on jobs. And while many of the jobs that we lost in the last year, majority of them have come back, there are still over 10 million Americans, workers that have not got jobs back, which is obviously not good for them, their families, the economy, ownership of homes, cars, everything connected with it. So we believe that this is an area that both for H1 and for PERM, for green cards, that the government is going to go after this, that they are going to make it more difficult for people who are paid on the lower end instead of the higher end. So to the extent that it's feasible, I think it's always better to go with, try to make it a higher level job. If possible, try to show the level 1 or 2 or 3 or 4. If you don't have 4, then 3. They don't have 3, then 2. Don't have 2, then 1. They are supposed to give it. Some people say, why should I do something that's, if the law allows me to do a level 1? Yes, of course. A lot of jobs allow and require, medical residents, for example, have to be level 1, because that's, even if you're a medical or sometimes tenure track faculty members, maybe just level 1, because it's or depending on the university or the school or community college, etc. You can do it, but we are concerned that both the U.S. Department of Labor and USCIS are going to start looking at it, because that one whole thing which they were looking at of forcing higher levels, that even though that has not become, some of that has just been put on hold, as you know, we think that some variation of it is going to come back and rear its ugly head. And I say ugly because the law under the H1B specialty occupation was never meant to go after the highest salary. It was meant based on the US government and the US economy having a shortage of high-skilled workers who can do the job. And as long as the job requires a bachelor's or master's degree in order to perform it, that's all that should be required. But they're overlaying it with more and more and more additional requirements which are not actually mentioned in the law. And I'm afraid that those are going to become included if we don't put our foot down or challenge the government or do something. So the short answer is, if you want your case approved, try to show it not in the lowest level 1, but really, even if it's level 1 today, you should be able to get the approval under the current system. We don't know how long it'll last. Maybe next year at this time, I won't be able to tell you to do that.
Got it, Ms. Murthy. Thanks for explanation. So could you please let us know, especially the ones students whose H1B got picked in the lottery, how do they leverage the cap gap, especially the ones whose OPT is expiring or expired from April to June, because that's something
Excellent
very important.
Point. Thank you, Ranjit. In fact, that was another update that just came out in the last 3 or 4 days, was the USCIS and SEVIS saying that they will automatically update the SEVIS database, the Student and Exchange Visitor Information System database, so that all students whose F1 OPTs are expiring after April 1, but before October 1, will automatically be considered to be enjoying the benefits of cap gap. Till now, this DSO has to put some information in, and it has to be put into the system, and you have to follow up with them and make sure, and you have the letter and you have the proof. But SEVIS has said they will do it. So this is the first time. We haven't seen it yet. They only said this 3-4 days ago. And so I think it was earlier, was it this week or end of last week, same Thursday, Friday of last week. And so we believe that clearly they realize that this is an area that needs some clear-cut guidance, because between SEVIS, the DSO, the International Student Advisors, or the designated school officials, there is some confusion on how to ensure that the student's name and database automatically shows that the student is covered and protected between that cap gap time of April 1st and October 1st.
So, Ms. Murthy, is it going to be for everyone or only for those whose H1B got picked?
Only if your H1B was selected, and not just selected in the pre-registration, actually filed. You have to file the H1B petition between April 1st and June 30th. And that's the catch, is, of course, some people who have already graduated, not a problem. Those who are not yet graduates have to wait till they finish their graduation. or show completion of all coursework. And only once you have filed the H1 petition with the USCIS. So if somebody's F1 OPT, let's say, expired in March, then you don't enjoy cap gap benefits at all, because you can only file your petition starting from April 1st onwards. But unfortunately, then you don't enjoy cap gap. So it's only after filing the H1B petition with the USCIS that, while it is pending, if you are selected and it is approved, no problem. If it's selected and you get a denial, then you no longer enjoy cap gap benefits.
So people, whoever OPT is expiring from now until June, file it as soon as possible, so you get to enjoy the cap gap. Otherwise, you may lose that benefit if it's already expired and timely H1B is not filed, right?
Timely, properly filed applications or petitions are required. And in my mind, if you know that you need cap gap protection, you're desperate because your F1 OPT has already expired, including STEM OPT 2-year extension, then do not file it under premium processing program in most cases, because you don't want to find out earlier if you get a denial. And even if you get an approval from October 1st, now it's not pending anymore. So you will not be as protected. While it is pending, you're protected, right? And with a start date of October 1st, you're protected. And if it's approved, you're protected. Ultimately, you're protected. But if it's not approved, or it's denied, or there's an RFE, or even if it's approved, it's not as clear cut as if it's pending. So my philosophy is, why pay extra money to find out and lose a valuable benefit like the opportunity to continue to work legally while on F1 OPT status?
Got it, Ms. Murthy. And another thing, so what's your advice for the students whose H1B is not picked in the lottery and their OPT is about to expire? I know there are a lot of options. Like, few people prefer day one CPT, masters and all, and few people say that let's do an PhD and then get a CPT. So what's your advice, and how careful they should be? Status is a very important thing when you are in US. So how do they make sure that everything is good and making it safe so that there is no issue down the line?
Yeah, so technically, according to the USCIS and the Department of Homeland Security, once you've completed your education, you've completed your optional practical training, technically you shouldn't be doing another degree, another OPT, another CPT. And in fact, in the last 3 or 4 years, as we've all seen with the Trump administration, if you keep on trying to extend your status by filing CPT, they even consider that possibly as a violation of your status, especially day one CPT cases. Some people try to work with cap exempt H1 employer, like a university or a hospital that is not subject to the quota. Or even if you're not working directly for them, if you're located with your consulting company at that location, you're still cap exempt. So you can file a cap exempt petition. It's an exception to the rule. The day one CPT, people do it because they're desperate. People, again, sometimes they really want to do a PhD. Sometimes they do it just to buy time and also to get the next higher level education. Because if you get a higher level education, then once you finish your PhD, then you can get another 1 more year F1 OPT for each degree that you complete. None of these are clear cut because are very safe, because of course they cost money. They invest more investment of time. And day one CPT has been working so far, but we don't know, again, as I said, in the last 3 or 4 years, they've been giving a hard time in approving. Finally, when after 1 year or 2 years, the person is selected in the lottery, the USCIS is saying, sorry, you were not in status all this time because we believe that your day one CPT was not correct. It was not an integral part of your education. It was not mandatory for you to do the day one CPT in order for you to complete your education. So the attitude was so there's definitely some level of risk by, enrolling in a university or a school that offers day one CPT, especially based on what we've seen in the last 3 or 4 years. But I know people are desperate. You've spent your hard-earned money, your parents' money. You've come here all the way. You really, really want to desperately figure out a way to stay here, work, and stay legally and not go back. But if the worst thing is going back for a few months and getting a new H1B petition, filing and coming back, showing extra experience under your belt, then it might be something to consider But if you're willing to do a PhD, then absolutely go for it. If you can get a cap exempt employer, then go for it. There's lots of options and see what makes most sense for you with your time, your money, your own personal desires of whether to invest your time working or studying or doing like the CPT, which is in between, where you're still supposedly studying, but also doing the curricular practical training, because that costs more to get admission, and to pay for tuition fees obviously is quite expensive in the United States.
Thanks, Ms. Murthy. Thanks for the advice. We have a caller from California. Shiva. Hi, Shiva. Welcome to the show. Please go ahead and ask your question.
Hi. Thanks for taking my call. Hello, Sheela madam. So I have a question. So my PR date is March 12th, and then last October we have downgraded EB2 to EB3. Got 140 approved couple of weeks back using with premium processing. So my spouse completed biometrics, but I haven't received biometrics appointment letter from USCIS. So just wanted to check if this is a common scenario which falls under the delays, or should we request USCIS for further information?
So did I hear you say, Shiva, that your spouse got it, the biometrics appointment, but not you? You did not get your biometrics, but it's only been a couple of weeks, right? So it's a few weeks this way, that way. Each case is looked at separately by law, because each person has to qualify, even though ultimately the person may be a dependent on your green card filing. So if it's a question of a couple of weeks, I wouldn't panic. But if it's several months, then of course I would start to worry about whether they've misplaced it, whether they forgot. So I even heard recently in one of the consultations I did, I think was it last week or this week, where somebody said that the USCIS said, we have a copy of your biometrics from when you traveled abroad or with some other application that you filed. So sometimes they might have the principal's biometrics with them already. And even in many cases, I've been hearing where they're issuing the EADs for people who filed in October of 2020 for one person or both spouses. And then the biometrics appointment letter came afterwards. So they're doing things all over the place, partially because the tens of thousands and thousands of applications that they got. And I think they're just trying to coordinate and schedule it so there isn't this huge, overwhelming deluge of cases that they have to deal with at one time. If it's just a question of a couple weeks, Shiva, I would stay put. If you think it's a mistake, you could follow up with them and say, hey, I'm the principal applicant. I didn't get my biometrics. My spouse did. But if you're lucky and you get your EAD approved and your spouse, they're looking to get the spouse's biometrics in order to approve your wife's H4 EAD, then maybe it's okay to wait a couple weeks if you're willing to be patient. And if you're not, you can certainly check into it. I know they've made it very, very difficult to contact USCIS by removing the customer service, putting fewer people, by making it more automated, by requiring you to go to the website to get the answers. And when you talk to a live person, most of the time, unless it's a tier 1, tier 2, tier 3 officer, most of them don't even understand immigration law. They're more like somebody just reading out what's written on the computer, in the computer. So it's very frustrating. As I have often said, it's only when government is involved that can they take so much money from you and give you no service for it. In private sector, all of us would have to be fighting to provide the best possible advice to clients. So long answer to give you the short answer. If you're comfortable, if it's a couple weeks wait, if you think that you are getting impatient and you want to, Shiva, then go ahead and just follow up and say, is this a mistake because I'm the principal applicant and my biometrics have not been issued? You can also try to touch base, as I told the previous caller earlier today, I think it was Raj, where I said, please go ahead and even write to the ombudsman if you think that this is a mistake, to fill out the form 7001. It's a free form, Shiva, and you can just go to uscis.gov and get it, fill it out and explain the nature of the problem. But it's possible that because we are hearing of different things happening with so much that's been going on in the last couple of months.
Thanks, Ms. Murthy. Thanks for your time. We are towards the end of the show again. Thanks for your time. Thanks for all the calls and watching the show. It was a great session with interesting topics and questions. Please call in every Tuesday at 3 p.m. EST to watch the special immigration show with Ms. Murthy. Again, it's every Tuesday, 3 p.m. EST on Sakshi TV. This is Ranjit signing off. Thanks, Ms. Murthy.
Thank you. Bye-bye.